Good evening, friends. Uh, though it's quite odd hours where normally we don't take the session at this point of time. But once you have a speaker like Justice Muhamed Mustaque, a judge of Kerala High Court, who we can say that has been patronizing various sessions in respect of the sessions we have taken with him, we had requested him to take a session that we have been all reading about, discussing about the Digital Protection, Personal Act, Data Protection Act 2023. And as usual, he was kind enough to take us into the deeper dives into this session. And before I request, sir, I will just make a request. Sorry, I just got myself muted. I will request, sir, because we know that it's all a working day, we will request, sir, to take over the session. And we all know that we will have a deeper dive into this particular act. Over to you, sir.
Thank you, Vikas. It's after long hiatus, got an opportunity to come back to your platform.
Thank you.
Very good evening to all audience who are here in a virtual mode. Some of them I personally know, some of them I may not know. I'm Justice Muhamed Mustaque, a judge in Kerala High Court. Been a couple of occasions I came to this platform to discuss on different topics. This time Vikas asked me to speak on any topic I asked him to select. He asked me to select either mediation enactment or digital personal data protection act. So I prefer a later, obvious reason that mediation may be many of your associates. And this is a new enactment which have a lot of impact in the legal profession and which would give a lot of impetus to the legal profession. Those who are looking in terms of another new avenue for practice in the future. And this is one area where you can think about it. The lawyers, it's a untrodden path. It's not a beaten path. So some of you had to make a niche on this and make a difference. Well, I would say the lawyers, by and large, in fact, to celebrate the offering of two enactments, which passed in not the last session of the parliament, the previous session of the parliament, because this will bring a new dimension to the legal practice, both Mediation Act as well as the Data Protection Enactment. But to celebrate, we should know the importance of it, and having not realized the importance even, we may forget to celebrate it. And that's what often happens with us. The legal profession is in crossroads in a way because they are not able to grapple with the new challenges and they are not able to respond to the new challenges. This is one of the biggest challenges we face because the way in which we train is a different, different terrain. And so therefore we are not able to embark upon a new journey. And we have a lot of constraints within ourselves because we are focusing on some areas and where we have already put in significant amount of experience and training, and therefore we don't want to look upon another area which we will have a lot of constraints. But certainly this is one area where many of you can think about treading a new path, because essentially I would say it would be more lucrative and will have a more monetary gain when you create your space in this, the platform provided by Parliament. Our Prime Minister, somewhere in 2015, spoke about Digital India. Many could not comprehend what is a Digital India. We could not realize the importance of digital transactions. How we said the ordinary person in the small vendor on the roadside would be able to have the idea of digital transaction. So today, when we see that in small vendors who are selling a tender coconut or some tea, they enable us to pay online. The digital transaction penetrate in such a level. You can see that wherever you go, you will find the 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 digital space are penetrate in such level. Ordinary man now is able to understand what is a digital transaction. We have around 700 million people in our digital space in India, is half of our population. We are the second largest user in the world in terms of using internet, besides the China. And we are far ahead of in terms of using digital space comparing to any other developed country like US and England, because obviously for the reason that we have a large population. The next decade of our revolution, when Prime Minister spoke about digital India, was speaking about growth of India in terms of economic growth, the GDP. One may realize we might be a bit critical of population growth, the Malthusian theory, which rather put blame on the population one point of time as something is hamper the economic growth. I think today's any economics may rewrite his ideas. Of course, I'm not an economist, not expert, but still I believe the economics may rewrite the principles relating to the economy, that population may become a boom for the economic growth. The country like India and country like China will decide the digital space of the world, the future, because we are the largest users. The population itself become a big asset for determining, and become decisive in digital space. Population itself become an asset. The Google has to survive, or any other search engine, or anything has to survive. They need a users, whether it be social media giants like Facebook, WhatsApp, and all. They need users. Without users, they can't survive. So who can provide users? In India. China has its own restrictions and limitations, but India has given a platform to the tech giants to leverage or capitalize our populace. That means India can also have a say in the future in regard to the regulations governing digital space. So India is going to be a giant in terms of digital space, and India will decide the future of economic space in the digital platform. So you are not looking in terms of an individual's benefiting it, or a corporate entity is benefiting it on the digital space. But India as such would assure a new economic order through measures consistent with the global standards. If you look at today's use of digital space, 80% of the railway bookings are done through IRCTC platform. The banking transaction has grown to such a level that 40% of the customers now use digital space. The e-commerce contribution has risen to 10%. Of course, it was much more during COVID period. So every Indian now is having a footprint on digital space. But that is exactly the problem that we're going to face in the future, because we cannot retain the digital space unregulated. The digital space to be regulated for its own growth, a steady growth. Today, the Europe, of course, is much advanced in terms of the data protection law. They have gone to the next level of enacting Artificial Intelligence Act. It came somewhere in 2023, I believe, June June or July 2023. But to regulate artificial intelligence, we need to have a very robust data protection law in our place. The data is a subject of artificial intelligence. That means there should be some sort of regulation for use, even with applications on a large language model like LLM. We call this a LLM, large language model. You might be now learning, you might have now all conversing with the ChatGPT, the generative AI, which has gone to a different level. Beyond the prediction, it also generates opinion. It can create images, it can create text. So that level we have reached. So it is in this background, we need to examine the recent the law passed by the Parliament, the Digital Personal Data Protection Act 2023. The preamble of the act itself states it covers only digital personal data and not physical personal data. So we have to remember first, it is all speaks about digital personal data, not about physical personal data. Unlike the European General Data Protection Laws, regulations of European Parliament, which covers both physical and digital space, Indian law is limited sphere and operation to digital space alone. Therefore, a lot of contentions, a lot of issues may arise in court in the future litigation, because what is exempted in the digital space may become a contention issue in the physical space. If you look at some of the exempted provisions, like exemption given to the court to process data, investigation team to collect data and process data, which are all exempted activity in this present enactment, sometimes also become a bone of contention in physical sphere, because that is not regulated so far by the law in India. Way back in 1980, OECD countries, guidelines were issued by OECD. OECD means Organization for Economic Cooperation Development. India is not a member, but it has been allowed certain kind of benefit of OECD organization. They formulated certain principles governing OECD countries. Originally, it is, I believe, there are 20 countries, developed countries. They issued certain guidelines for processing personal data, which later became the subject of European directives issued way back in 95. It's called 95 European Directives 95/46. The guidelines, in fact, contain certain core principles related to the personal data protection in digital space. So these core principles form part of the basic structure of data protection law, either in Europe or in India. In GDPR, in Article 5 narrates what are the principles. Of course, in Indian law, it not specifically referred to those principles, but if you browse through the different provisions, different sections, you will find the core essence of these principles are reflected in those statutory provisions. I shall briefly refer to the few of the principles which originally I said found in European guidelines and later in European directives 95/46, and of course in GDPR. GDPR, in fact, was formulated somewhere in 2016. The first principle is related to collection limitation principles. That means the data collection should be based on lawful and fair means with the knowledge and consent of the data subject. So collection limitation principles means you should put notice of the individuals whose personal data being subjected to such transaction or transmission. You should have a notice and you should have knowledge. In Indian law, the data protection law, it says any constitutionally recognized language, such notice should be given to the data principal. Means the data principal means the individual who's subjected to whose data is being subjected to transmission. So Section 6 of Indian law, which says that a consent should be obtained with the knowledge. So one should know about his data is being transmitted and processed for certain legitimate purposes. So consent should be. You cannot, somebody cannot, that means data fiduciary who is collecting, who is determining the data, cannot obtain such data without consent. If such a violation would inevitably results in a huge penalty. If you look at the schedule of data protection law, the imposition of penalty varies from 50 crores to 250 crores. Only exceptional as a minimum kind of penalty is on data principal when you impersonate or individual who impersonate or give wrong information, because he's also have certain duties under the law under Section 15. And if he violates, maybe he's visited with a penalty of 10,000. But in all other cases, the penalty is huge. That's what I said. This is something where lawyers can leverage. The two ways of lawyers can privilege this data protection law. One way of it, ensuring complaints by the companies or entities or individuals who are involved in collecting this data. The complaints aspect is it would ultimately result in, setting up a robust environment of digital space for transactions. The banking companies, the credit information service companies, many other companies or many other entities collecting our data, personal data, including phone number, email address, etc. All this forming part of personal data. You might be required to advise them regarding complaints. And of course, the lawyer's part, if there is any breach, they will be able to take up the cost of their client, who is the data fiduciary, data principal, for any violation. And that may ultimately results in huge penalty, as I mentioned earlier. The second principle, which is first principle I referred, the data collection limitation principle. Second principle is the data limitation principle. Data quality principle. That means the data collected must be relevant to the purpose for which they are used or they have been collected, and must be complete and accurate. The quality principle would ensure the accuracy and complete, and it need to have a nexus with purpose for which it is being collected. That is one of the principles referred in the European guidelines, as well as, of course, I will not find it exactly as a principles in our law, but you can find that underlying provisions, the provisions, the very basis of these provisions are related to these principles. Then there's a purposive principle. Purposive principle means it should have a purpose, which should be specified. I collect the data fiduciary collect this principle. Should collect this principle. Some questions have been posted. You can post questions later on, because I would respond to your question if possible after the session is over. It is being popped up here.
So we take questions from the YouTube also, so everybody knows who is there. We will take the questions at the end of the session.
Yeah, purpose should be specified. So that there should be as purpose, and that should be specified while consent is being obtained. Use of limitation principles. Personal data should not disclose if incompatible with the purpose, so that you can't use beyond the purpose for which it is being collected. The security principle. The security principle should be protected by reasonable security safeguards against Such risk is lost, unauthorized access, restrictions, modification, disclosure, etc. So you need to keep your bound the data fiduciary is and the bounden duty is to ensure that the data collected is protected and it is not leaked or some other entity. Of course, reasonable safeguard will have to be made. These are the core principles on which if you browse through the relevant provisions of law, because I'm not here to teach on each provisions of law and give a discourse on it. I know that limitation of the time we have. Now there are exemptions which is you can find. Somebody asked the question which how to consent has to be obtained. They specifically state in what manner the consent has to be obtained, and it has to be the section 6, the purpose consent given by principal shall be free, specific, informed, and conditional, unambiguous, with a clear affirmative action shall signify an agreement to the processing of personal data for specific purpose and limited with such personal data as necessary such for a specific purpose. That's what section 6 says. I have a copy of legislation with me on my table here. And it shall be in a particular language which is conversant to the data principle. And that's why all constitutional recognized language has been accepted for obtaining such consent. Now, interestingly, this enactment, we had to call it the she enactment because instead of gender he, normally it's found that it's this enactment specifically says all gender has to be addressed in the name of in she pronoun. And therefore, we can call it the she enactment. She is understood, includes E also. Now, the problem may arise when you see that section 617 of this enactment. 17 of this enactment given a host of exemptions from the strict regimen of this enactment, is including this. Much of the litigations happening today is in the court. Many of the litigations have been thrust before the court based on right to be forgotten, which is specifically referred in the GDPR, but not here in the RO enactment. I'll explain what is the right to be forgotten. Right to raise, of course, both are interchangeably used in European GDPR. But here the exemption has been accorded for certain nature of class of personal data for enforcing a legal right or claim, processing personal data by any court, tribunal, etc. Personal data is processed in the interest of prevention, detection of investigation, prosecution. Personal data principle not with the territory of India is processed pursuant to any contract entered with any person outside the territory of India by any person based in India, etc. You will find that section 17 carves out as exemption. This is exactly the problem I said earlier. When Supreme Court in Dr. Puttaswamy's case declared the privacy is an integral part of the fundamental right, it's for the court to interpret what forms part of what particular actions or inactions would qualify the privacy. In that sense, those who exempted category may qualify for an action in physical space when there is a violation on the ground that there is a violation of privacy. What is exempted? We can say the operation of the law is limited in digital space, and the act itself is called the Digital Personal Protection Law, Personal Data Protection Law. In that sense, what are exempted under Section 17 can be subject to a challenge in its physical space if there is a transmission of physical data through medium of like print media or any other media. This is very problematic for the court to deal in the future, I believe. This is one issue which may likely to crop up in the future. See, I refer to the right to be forgotten, right to rest, of course, both interchangeably used in GDPR, which in fact, I'll explain what is the right to be forgotten. The French jurisprudence recognized initially law oblige the law that right to be forgotten. long back. I believe this ideas developed in 18th century or 19th century, but later court started applying this doctrine somewhere in uh, late 90s, where an accused of criminal cases, he has every right to forget his past and live for the future. That's what the underlying principles. It has been recognized by the European Directives 95/46, not in the same way of right to be forgotten, but it is in a way that's based on the storage principle, which I not, of course, I not mentioned it, because if you require a certain data for a certain period, or it only purpose for it is when the purpose is served, you cannot no longer retain that data with you. That is the core principles related to storage principle, storage limitation principle. That means if you have secured certain data, that you can keep with you, the data fiduciary can keep that data so long as it required in accomplishing its purpose. Thereafter, it cannot. This exactly created a furor in the European Union, where the Google faced an action. Google Spain versus APCD. APCD is an agency, European Data Protection Body or agency in Spain, where a person who something similar to a securitization enactment, somewhere his 90s, his house was auctioned, and it came in newspaper like we now, the banks are now advertising for the sale of the remote property of the defaulters or the debtors of the bank in the securitization enactment. Similar way that an ad came in a newspaper or some other medium. And of course, you know that online medium also it came. The Gonzalez, I believe its name is Gonzalez. The Gonzalez, after a decade, when he Googled, the moment what is surfaced in the digital space is that the sale of the immovable property, which happened somewhere in 90s. This action was initiated in 2001 or after, post 2000. So European Union Court decided in favor of Gonzalez, say on the storage limitation principles, which is reflected in laws in Europe in 95/46, where it say that data cannot be stored beyond the purpose for which it was collected. So holding that he has a right and the data cannot be retained beyond it, because Google is profiting out of it, the search engine, and Google was directed to remove. This is what famous case called Google Spain versus APCD. You might search in the Google, you'll find out the case details summary you can find. But in GDPR, which is brought in 2016, there is a specific reference to the right to be forgotten. That means that limitation of storage principles may not as such need to apply in such situations, where the special chapter is provided on the right to be forgot. Of course, in rather it is interchangeably used in right to erasure. That means one has a right to forget his past and live for a moment and lead to the future. But Indian law explicitly is absent in the Indian law in regard to these rights. So our constitutional jurisprudence calls for us to decide on the parameters or borders of the privacy, right to privacy, whether it falls in the right to privacy. In fact, I had an occasion to consider this issue in dealing with a couple of batch of cases before me, when court judgments are posted online, it reflects the names of the accused and it reflects the names of the parties. This is a dilemma for the court. But the court has to balance both. The court is a public institution. In Swapnil Tripathi's case, Supreme Court has held that even the public should have an access to the view the court process. That's why the live streaming has started by all the courts in India. In that sense, court is open and a public place. Everybody should have an access. So we can't limit, and for the legislature to limit the such space. And being in a public space, and data is bound to be disseminated, except in the matters of law requires to accord protection. The family matters, the Family Court Enactment, Hindu Marriage Act accord certain protection of such details of personal details of the parties. In that case, party can signify their intention and request a court to withhold personal information being disseminated in the public space of court information system. Apart from that, court declined all the other relief in regard to the accused. Many of them were acquitted, many of them were discharged. But court, it is not for the court cannot balance how the individual interest and public interest. It's a matter for the legislation to decide, because one need to know the past of an individual. You can't deny the right of the public to know about the past of an individual. To what extent, how long is all matters to be decided by legislature, though they have made out a case based on the right to privacy. But court cannot enter into the arena of legislature where their wisdom should be applied to balance both public interest and individual interest. This is how court decided those matters. But anyway, these are all matter of contention before the limited different courts in the India as far as the dissemination of the information which is available in the court information system. So as such, we cannot apply in regard to the principles of right to be forgotten or right to erase as referred in the European law in the same manner it has been contemplated in the European, but in a limited way of bordering privacy. Court may be able to use these principles to relate it to the protection of privacy in the light of judgment of Apex Court in Puttaswamy's case and apply in case-to-case basis. If, for example, eraser, sometimes right to eraser may to be applied in certain occasions where the accused found to be totally innocent of allegations leveled against him, and it might be sometime he might have been implicated in a criminal offense due to mistake or misunderstanding. In those cases, if his name surface in the digital space, he should have a right to erase those data coming up in digital space. So these are all matters to be decided in case-to-case basis. We can't have a uniform principle to be applied in such matters. As I already mentioned to you all, the bone of contention likely to happen before the court in the future, maybe in relation to matters now being exempted under Section 17, can be a subject matter of a challenge if same actions may violate privacy in physical space. This is a matter to be decided in an appropriate time. Now, these are broader way of I mentioned it about it. I'm not taking into the nitty-gritty of each provisions of the law which is mentioned it, but that you can also go from the enactment. But I must refer to you as many of your academics and lawyers, there are platforms being provided in this enactment. One is a Constitution of Data Protection Board of India. That is a primary level of adjudicator. It would adjudicate all complaints relating to the violation of personal data. And the very important aspect of it, it operates in a digital space and digital office. You can raise your complaint online. The adjudicator will be provide online platform for adjudicating it. And ultimately concluded that there is a violation, it can impose any of the penalties as referred in the schedule. That is referred in Section 33, that after conducting inquiry, that board can impose such penalty as referred in the schedule. Next level of appellate authority is also formed. It has been assigned to TDSAT, that you know that Telecom Dispute Appellate Authority, TDSAT. The TDSAT is an appellate authority, and award and order passed by this also can be enforced as the civil court. So this is a significant aspect of it. The statute itself contemplate a digital office of the Data Protection Board of India. So from any part of the country, the one may be able to lodge the complaint or grievances with a digital platform. Now, two aspects I want you all to deplore on. I mean, I need the audience or youngsters who are here to think about when we are leveraging this digital space. The data protection law may be regiment certain levels, certain will accord protection. We don't have a law in this country in regulating artificial intelligence like manner the European Union has brought. European Union has brought the Artificial Intelligence Act, and which prohibits high risk taken out of its potential danger to the public. The consequence, ultimately, this data which is coming to the digital space, ultimately used by someone else to leverage it. You know that how the Cambridge Analytica, I believe Cambridge Analytica went into trouble. They used Facebook data for some other purposes, and they also went into controversy. Maybe in a way, this data protection law, which would enable us to the data fiduciary and accountable, but next level of it, when it goes beyond the territorial jurisdiction of the country, and when it is being used by the machines, used by algorithm, large language model I already mentioned about you, it's only an algorithm, and which will have a larger impact in our life. The European Union classifies high risk, medium risk, and low risk. Low risk are something is permitted. Its broader category has been provided. That itself would regiment the next level of revolution through artificial intelligence. That perhaps may be one thing we may require in the future. Secondly, the law in application of state responsibility have not developed much in India. Though international law, you might be aware, many of the students might be aware, the state responsibility under international law, certain type of it. But law is yet to be evolved around state responsibility in the sense when there is a challenge from into the digital space. How far and what extent our country is responsible for such challenge. And domestic law is something we need to ponder on this. You know, you might be knowing that government of India has established CERT. CERT is a body which is watching all cyber attacks on our digital space, and state is also responsible to protect us from inevitable attack of our digital space. Of course, when a digital space is attacked, you know you will be losing all your data, and all what is being considered as a personal, what are being has been protected under law will be also lost. So, what extent the state would be responsible if such attack or cyber spoofing or some sort of attack is perpetrated beyond the territory of India? How far and what extent the state is responsible? These are all broader area where law need to be developed. Anyway, this Digital and Personal Data Protection Act would lay down certain foundational principles for us to grow. And next level of our growth would depend upon how the lawyers and academics leverage this enactment, and for the growth of e-commerce, the growth of digital space, on whatever level. When the population, I said earlier, the population itself become a big asset for us for leveraging a new milestone and strengthen our GDP. So these words, I would conclude. Any questions? Of course, subject to my limitation. Many might know I'm a sitting judge of this Kerala High Court. I have my own limitations, which would apply to me. I cannot express opinion about, except I can only refer to some of the provisions. If so required, I need to go through again the statutory provision to make you understand what actually the provision of the law is intended. Beyond that, I have my own limitation commenting upon contentious issue, which may come before me in a different form in the future. Thank you.
So only one question so far has come on the chat, and Santosh has divided it into two parts. About the data collection principle, it's said about the consent. How do you obtain the consent for the legacy data?
The consent has been mentioned I said in section 6, I believe, section 6, and one minute. He is referring to form of consent. I mean, is it not that question, that form of consent?
So he says how do, that's of course just like whenever we buy something and somebody that I agree.
Yeah.
He's saying it is on the same tangent. It says, how do you obtain the consent for the legacy data?
Legacy data, you mean, see that the personal data which you have been consenting for transmission, it has to be current. You are referring to legacy data. I mean, what context do you mean?
So he will post. Meanwhile, A.K. Sharma says, is the Data Protection Board of India been constituted?
I think it has to be notified. All this has to be notified. I believe it is not notified, I believe.
Yes. And Akshay Panwa says,
the consent is section 6 and all, and it's also referred to the some of the provisions relieved. It has the all constitutionally recognized languages, even in vernacular language. It has to be signified, and you must expressly affirm that consent of processing data. For example, in banking transactions, the bank has to notify your data will be processed, and it has to be in a language known to the data principle. The consent has to be most an affirmative, not a passive consent. That's what provision says. The passive consent, of course, you know that nowadays you click some button and give a passive consent, but it has to be very affirmative action. That's what the law says.
The next question is, what topics do you feel that one has to study to make career in this act?
I think there are way of looking at an act from different angles. That's what I said. One is to, in terms of complaints. Many entities would require a lot of complaints. You need to know the technical parameters. You need to know kind of issues likely to arise in the future. If any, for example, the security angle, one need to know what kind of security need to be, what extent, what level of security to be afforded by the data fiduciary. You need to know what are the steps to be taken to protect such data. You need to know you need to, ensure that complaints at all levels. That's one way of a law of looking at it in terms of a lawyer's perspective. Other way of looking at it is in terms of any violations of this. In what manner the violation has to be established. Both involves a lot of skills in a way, because it would be easy to say that it's violated, what level, and how, in what manner, how to establish. So it is all involves a lot of inquisitiveness of like a lawyer. So in both ways, the study, you can't be merely looking at the data protection law. It need to go beyond. You also need to know how the system operates in a digital space. There may be an occasion where the cyber attack or cyber stealing might be perpetrated by a machine algorithm. So you may not necessarily be perpetrated by some other machine. What extent that algorithm could be made accountable, and how, what action, what manner. These are all technical parameters. I'm not very conversant on those areas. But in a way, there are broader angle for young law students, the young lawyers, to study in a focus on these issues, which will definitely grapple the code in the future in whatever in different multi-dimensional way. It may come as a mere challenge against orders of bodies like Data Protection Board or TDSAT, or in a way which you may find that is being more bordering the issues of fundamental right, like violation of privacy. And different angle it may come.
This is by Krishna. He says,
legacy data, I don't know. The legacy data, it has not been mentioned about it because it can have only prospective application, but legacy data is steadily to be protected. That's what I've said. It is only because consent, because already we have, all of us have provided our data to the bank officials. In what manner this legacy data, I have no clue on how about this in a particular legislation. Anybody have any opinion, of course, they can share. Already the data already collected. It's what I'm saying. To my view, or I only a learner of this. I'm not an expert. Only I came across this legislation. Though I have learned about data protection law of European Union long back for my academic purpose, I don't have any other of your connection. Those who have any idea of legacy data or the data now being collected for prospective use, and that would be a matter of a deliberation among all of us.
This is on the WhatsApp I've just received from Sumesh Anthony. He says, what will be the impact on the educational institutions? Will those data also fall under the data fiduciaries? So it's not on the chat. I just received the WhatsApp. It is by Advocate Sumesh Anthony. He says, what will be the impact on the educational institutions? Whether that will fall within the data fiduciaries?
Yes, definitely. See, the exempted categories enumerated under Section 17.
Yeah. The last question we will take, because we know that you were tight pressed with the time, but still you.
The Section 17 enumerated only certain class of exemptions, which is more related to the investigations, processing your, through the code or some other merger and amalgamation or financial information. Information is received or collected for some credit worthiness or something. In that, only exempted categories are enumerated in Section 17, not beyond that.
The last question by Dr. R.P. Gupta. He says, if some corporate holds a technology where they can pull the data by just using my mobile, then is it illegal, or how to act against that person?
Pardon?
He says that somebody uses the data, he pulls up the data by using just the mobile. Then is it illegal, or how to act as an individual? Like normally we see that they ask you, let's assume we also get that you should get yourself registered in for a Zoom call. And then I share those data. What will be the impact thereof?
You are bound to protect the personal data. You cannot share that data because you become a data fiduciary. Data fiduciary has been defined in this enactment. Means any person who alone or in conjunction with other person determines purpose and means for processing personal data. So you collected this data only for the purpose of this meeting. You cannot now use.
So everybody actually feels. I think that this Digital Personal Data Protection Act will actually help, because it was always said that once you have the data, then you become the king, and that's what in the marketing team sector they were using. And I think there's one last question, and then we will not take any question.
See the, the study has to be done by, the academics and the young lawyers. How to look at the GDPR, how it has grown in the European Union, and how the personal data laws have become so robust and so regimented in Europe, and try to apply certain principles into Indian context. As I mentioned earlier, the core principles under both GDPR and Indian law are same, but operational limitation is there in both, and I mean in Indian law, which classifies certain is exempted, and it's also somewhat lightened up certain loose ends. But nevertheless, it's the basic structure of both regime is same. So one is looking at the European Court Union's decisions and all, may be able to have a more broader idea how the European courts have dealt this kind of issues, which is maybe the most useful repository for all of us for our guidance to understand many of these laws. For example, which one I mentioned earlier, like the Google Spain's case, the same thing, the limitation principle. The today we all see that securitization enactment. What would be an exempted, maybe how long, what extent, that would be a contention issue in the future. May not be today, but after 10 years, this collected purpose is over. Then why should remain in the digital space? It would be an issue.
The last question, because we are in a gray area, but Advocate Lina says, to what extent we can make use of this statute to regulate the activities of new gen online news channel reporters, etc., who reveal everything about a crime under investigation or personal issues like matrimonial issues?
The news channel, I mean, it's a public space in a way. They are not collecting your data, but they are only revealing it, the news identity. If it may be bordering an action under many laws like Joint Protection Act, POXO cases where covers certain protection. They can't reveal the identity. The law is not the digital data protection law, but the Joint Protection Act, I believe there are provisions under the POXO Act, what we call as a protection of acts, that some of the provisions says that you can't reveal the identity in what so manner. So if that provision alone would be attractive in those cases, not digital protection law, data protection act, including matrimonial. That's only news coverage of a particular issue, because data principle is not concerned and not for data transmission.
Yeah. So thank you, sir, for sharing your knowledge, and we are deeply indebted. On Saturday, do connect it with us on this platform of Beyond Law. The Art of Mooting by Professor Nilima Barbade at 6 p.m. Thank you, everyone. Stay safe, stay blessed. And thank you, Justice Muhamed Mustaque, for sharing his knowledge. We always look upon to have insights on a topic which is fresh, and it's, I can say, in the baby steps. Thank you.
Thank you, Vikas. Thank you to all. I don't know I've done justice to you all, but in a way, whatever knowledge I have, I try to share with you.
Oh, no, everybody.
Not an academic, not a person who I don't have much time now to spend on.
The chat shows that so many thank yous means that they have appreciated whatever you have shared. And at least so, I can say on my side that they say that the heart is on the left, but it always thinks right. So I know that I've understood a much better, deeper side.